Good afternoon, everyone. Now we've come to the second part of today's webinar, Anti-Money Laundering and Counter-Financing of Terrorism, Requirements for Licensed Moneylenders. I'm going to introduce to you a guideline called Guideline on Anti-Money Laundering and Counter-Financing of Terrorism for Licensed Moneylenders, what we call the AML guideline. So the AML guideline is revised from time to time whenever it is necessary, and it was last revised in March this year. It was promulgated by reference to the requirements set out in the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, and it provides guidance to licensees and their senior management, as well as their staff members in designing and implementing their own policies, procedures, and controls in the relevant operational areas so that they can meet the relevant AML CFT statutory and regulatory requirements. Licensees are reminded that non-compliance may cast doubt on whether the licensee is fit and proper to carry on business as a money lender, and whether its officers are fit and proper to be associated with the business of money lending. In Hong Kong, there are also other legislation relating to money laundering and terrorist financing, financial sanctions, and financing of proliferation of weapons of mass destruction. To name a few, they are Drug Trafficking Recovery of Proceeds Ordinance, Organized and Serious Crimes Ordinance, United Nations Anti-Terrorism Measures Ordinance, United Nations Sanctions Ordinance, and also Weapons of Mass Destruction Control of Provision of Services Ordinance. And now we've come to customer due diligence, what we call CDD measures that licensees are required to take. So the CDD measures includes the following. First, identify the customer and verifying the customer's identity. Second, identify and take reasonable measures to verify the customer's beneficial owner's identity. Third, obtain information on the purpose and intended nature of the business relationship, if any, established with the licensee. And four, if a person purports to act on behalf of the customer, identify the person and take reasonable measures to verify the person's identity and verify the person's authority to act on behalf of the customer. For example, if your customer is a legal person, say a company, then you ought to first identify the person giving the instructions to you. And also you need to take reasonable measure to verify his identity by checking, for example, about resolution, authorizing this person to act on behalf of that company. So when are you going to carry out CDD? There are 4 situations where CDD should be carried out. The first is before establishing a business relationship with the customer. And the second is before carrying out an occasional transaction involving 120,000 Hong Kong dollars or above. The third is when the licensee suspects that the customer or the customer's account is involved in ML or TF, or when the licensee doubts the veracity or adequacy of any information previously obtained during the CDD process. Licensees are reminded that if the requirements are not complied with, the licensee should not establish a business relationship or carry out any occasional transaction with that customer. In case a business relationship has already been established, it should be terminated as soon as reasonably practicable. So for different types of customers, different types of documents ought to be collected from them. So for natural persons, you may refer to paragraph 4.3.2 to 4.3.4 of the AML guideline. For example, those documents would include a copy Hong Kong ID card of that natural person. And for legal person, including a partnership or an unincorporated body, you may refer to paragraph 4.3.6 to 4.3.9 of the AML guideline. For example, it will include a certificate of incorporation of a company. And for trust or other similar legal arrangement, you may refer to paragraph 4.3.10 to 4.3.12 of the AML guideline. For example, it may include a trust deed. What we've just talked about is the normal, usual CDD measures. But in certain situations, licensees ought to carry out additional measures or enhanced due diligence, what we call the EDD. So situations in which additional measures or EDD apply include situations presenting a high MLTF risk or situations specified by the registrar in a notice in writing given to the licensee. Politically exposed persons, PEPs, or customer not physically present for identification purposes. Now we're going to look at each situation one by one. So the first situation involves a high MLTF risk. A licensee should apply EDD measures in relation to a business relationship or a transaction to mitigate and manage the high MLTF risk in the following situations. The first one is a situation that by its nature may present a high MLTF risk, taking into account the potentially higher risk factors set out in the next slide, or a situation specified by the registrar in a notice in writing given to the licensee. Examples of potentially higher risk factors include customer risk factors, product service transaction or delivery channel risk factors, and country risk factors. Customer risk factors include, for example, business relationship is concluded in unusual circumstances, or when legal persons or legal arrangements involve a shell company without a clear and legitimate commercial purpose, or companies that have nominee shareholders and directors, bearer shares or bearer share warrants, or cash-intensive business. And product service transaction or delivery channel risk factors include anonymous transactions, which may involve cash, or frequent payments received from unknown or unassociated third parties. And country risk factors include, for example, countries or jurisdictions not having effective AML or CFT systems, countries or jurisdictions having a significant level of corruption or other criminal activities, countries or jurisdictions subject to sanctions, embargoes, or similar measures issued by, for example, the United Nations, or countries, jurisdictions, or geographic areas providing funding or support for terrorist activities, or that have designated terrorist organizations' operation. So what are the EDD measures which you may take? Examples include obtaining additional information on the customer and updating more regularly the identification data of customer and its beneficial owner. Obtaining additional information on the intended nature of the business relationship. Obtaining information on the source of wealth or the source of funds of the customer. Obtaining information on the reasons for intended or performed transactions. Requiring the first payments to be carried out through an account in the customer's name with a bank subject to similar CDD standards. The definition of PEP can be found in Section 1, Part 1, Schedule 2 to the AML. There are two categories defined under the AML. It is politically exposed person and also former politically exposed person. You may have a look at the definition later. And there are four categories of PEPs in the AML guideline. So the first two are non-Hong Kong PEP and a former non-Hong Kong PEP actually share the same definitions in the AML. And under the AML guideline, there are also two categories of PEPs, which are a Hong Kong PEP and also an international organization PEP. For this EDD measures for non-Hong Kong PEPs, you may refer to paragraphs 4.9.10 and 4.9.11 of the AML guideline. And for EDD measures for Hong Kong PEPs and international organization PEPs, you can look at paragraph 4.9.18 of the AML guideline. I would like to highlight to you the treatment for former PEPs. So if your customer is a former PEPs, you may adopt a risk-based approach, which means that the higher the risk, the more documents you should ask for. And the lower the risk, you can consider not to apply very stringent requirements and to ask for less documents in identification and verification. So if your customer is a former PEP and he or she does not present a high risk of ML or TF based on appropriate assessment, licensees may decide not to apply or continue to apply the EDD measures and enhanced monitoring measures. The third situations in which additional measures should be adopted is when the customer is not physically present for identification purposes. In these circumstances, at least one of the following must be carried out. For example, you can further verify the customer's identity on the basis of documents, data, or information referred to in paragraph 4.3.1 of the guideline, but not previously used for the purposes of verification of the customer's identity. Or you may take supplementary measures to verify information relating to the customer that has been obtained by the licensee. Or you may also ensure that the payments, or if there is more than one payment, the first payment made in relation to the customer's account is carried out through an account opened in the customer's name with an authorized institution or a specified institution. However, if a licensee has verified the identity of the customer on the basis of data or information provided by a digital identification system that is a reliable and independent source that is recognized by the Registrar of Moneylenders. The licensee is not required to carry out any additional measures set out above. If you do not want to carry out the CDD measures yourself, you can also engage an intermediary to do it for you. However, the ultimate responsibility for ensuring that CDD requirements are met still lie with you. When relying on an intermediary, a licensee should first obtain written confirmation from the intermediary that the intermediary agrees to act as the licensee's intermediary and perform which part of the CDD measures specified in the AML, and be satisfied that the intermediary will, on request, provide a copy of any documents or a record of any data or information obtained by the intermediary in the course of carrying out the CDD measures without delay. In Hong Kong, there are two categories of intermediaries, and that include financial institutions and also professional intermediaries. Now, I'd like to introduce to you a concept called ongoing due diligence requirements. A licensee should continuously monitor the business relationship with a customer in two aspects, that is ongoing CDD and also transaction monitoring. For ongoing CDD, the licensee should review from time to time documents, data, and information relating to the customer obtained for the purpose of complying with CDD requirements to ensure that they're up to date and relevant. For transaction monitoring, the licensee should scrutinize the transactions of the customer to ensure that they're consistent with the licensee's knowledge of the customer and its business, risk profile, and source of funds. And the licensee should also identify transactions that are complex, unusually large in amount, or of an unusual pattern, and have no apparent economic or lawful purpose, and examine the background and purposes of those transactions and set out its findings in writing. During the ongoing due diligence process, licensees should undertake review of existing CDD records of customers on a regular basis and or upon trigger events, and develop clear policies and procedures, especially on the frequency of periodic review and what constitutes a trigger event. High MLTF risk customers should be subject to a minimum of an annual review and more frequent reviews if deemed necessary to ensure that the CDD information retained remains up to date and also relevant. For transaction monitoring, the licensees should establish and maintain adequate systems and processes to monitor the transactions. They should regularly review the adequacy and effectiveness of their transaction monitoring systems and processes, and conduct transaction monitoring following the risk-based approach. The extent of monitoring should be commensurate with the MLTF risk profile of the customer. The licensee should also properly document the findings and outcomes of any steps taken, as well as the rationale of any decision made after taking these steps in writing, and make them available to the registrar, other competent authorities, and also auditors. Record keeping. So for how long should those records be kept? For each customer, the document should be kept throughout the continuance of the business relationship with the customer and for a period of at least 5 years after the end of the business relationship. For occasional transaction involving an amount more than 120,000 Hong Kong dollars, at least 5 years beginning on the date on which the occasional transaction is completed. And for each transaction, the records should be kept for at least 5 years after the completion of a transaction, regardless of whether the business relationship ends during that period. You may also take a look at what documents should be kept, and details can be found in paragraph 8.3 and also 8.5 of our AML guideline. So we've covered legislation and guideline on anti-money laundering. Now we move to the legislation in relation to counter-financing of terrorism. The United Nations Anti-Terrorism Measures Ordinance criminalizes the provision or collection of property and making any property or financial or related services available to terrorists or terrorist associates. You may look at sections 6, 7, 8, 8A, and 11L respectively in relation to different restrictions. For financial sanctions, it is an offense under the relevant regulation of the United Nations Sanctions Ordinance for any person to make available, directly or indirectly, any funds or other financial access or economic resources to, or for the benefits of designated persons or entities, persons or entities acting on behalf or at the direction of the designated persons or entities mentioned just now, or entities owned or controlled by any persons or entities mentioned just now, or to deal with, directly or indirectly, any funds or other financial access or economic resources belonging to or owned or controlled by such persons and entities falling within A above. Licensees are reminded not to have any business relationship with any sanctioned individuals or entities, or any terrorist or terrorist associates as defined under the UNATMO. For counter-financing or proliferation of weapons of mass destruction, in Hong Kong, there are 2 pieces of relevant legislation or regulation. The first one is United Nations Sanctions Democratic People's Republic of Korea Regulation. And the second one is Weapons of Mass Destruction, Control of Provision of Services Ordinance, in which Section 4 prohibits a person from providing any services where he or she believes or suspects on reasonable grounds that those services may be connected to weapons of mass destruction. And now we've come to database maintenance and screening. Licensees should establish and maintain effective policies, procedures, and controls to ensure compliance with the relevant regulations and legislation on TF, financial sanctions, and PE. To identify terrorist suspects and possible designated parties and detect prohibited transactions. Maintain a database of names and particulars of terrorists and designated parties, which consolidates the various lists that have been made known to the licensee. Alternatively, licensee can also subscribe to such a database maintained by a third-party service provider and take appropriate measures such as conduct sample testing periodically to ensure the completeness and accuracy of that database. Licensees should make sure that the following are included in their database. The first is the list published in the Gazette or on the websites of the Commerce and Economic Development Bureau. And the second is the list that the registrar draws to the attention of licensees from time to time. In addition to the establishment of the database, licensees should also implement an effective screening mechanism, which should include screening its customer and any beneficial owners of the customers against current database at the establishment of the relationship, and also screening its customers and any beneficial owners of the customers against all new and any updated designations to the database as soon as practicable. The screening requirements should extend to connected parties and persons purporting to act on behalf of a customer using a risk-based approach. In cases of suspicions of money laundering, terrorist financing, financing of proliferation of weapons of mass destruction, or sanctions violations, a suspicious transaction report, what we usually call a STR, should be made to the Joint Financial Intelligence Unit. It is an offense commonly known as a tipping-off offense to reveal to any person any information which might prejudice an investigation. If a customer is told that a report has been made, this would prejudice the investigation and an offense would be committed. However, making inquiries to customers when conducted properly and in good faith will not constitute tipping off. If a licensee reasonably believes that performing the CDD process will tip off the customer, it may stop pursuing the process, and the licensee should document the basis for its assessment and file a suspicious transaction report to the JFIU. So now we've come to the last topic of my sharing today, staff training. Ongoing staff training is an important element of an effective system to prevent and detect MLTF activities. Licensees are reminded of several aspects in order to effectively implement AML CTF training. The first one is that the scope and frequency of training should be tailored to the specific risk faced by the licensee and pitched according to the job functions, responsibilities, and experience of the staff. Licensees should implement a clear and well-articulated policy for ensuring that the relevant staff receive adequate AML CFT training. Licensees are encouraged to consider using a mix of training techniques and tools in delivering training, depending on the available resources and learning needs of their staff. Licensees should also monitor the effectiveness of their training, and they should also maintain records of who have been trained, when the staff received the training, and the type of the training provided for a minimum of 3 years. So now we've covered most of the important parts of the AML guideline, but the topics in this presentation is not exhaustive. So licensees are reminded to read the guideline themselves and familiarize themselves with the contents of the AML guideline. So in order to ensure due compliance. That's the end of my presentation today. Thank you.